several years ago, the planning director and legal counsel got together and decided for matters that were under appeal that it would be advisable not to adopt an ordinance because it could result in necessity to repeal an ordinance if LUBA reversed or made some significant changes. And so that was the policy that we were operating under when this case was a decision was rendered, and that's why we have the delay between decision and findings and now consideration of an ordinance. But as far as immediate impact locally, I don't see anything that happens.
I wonder, I don't recall being part of that conversation with the previous planning director and the previous legal counsel on establishing that new policy. I think to a degree it makes sense, especially if we have a history of cases from Josephine County going to the Land Use Board of Appeals with a remand to change something or to look at something a little more closely that we had gotten wrong. I don't recall any of those situations happening since that policy was changed by planning and legal. So if we don't have a history of it, my understanding is that my personal feeling is that by the diligence of our Rural Planning Commission, the evaluation of this board and codifying its findings in a way that has not met with any challenge successfully through LUBA, that we've got a pretty good track record of being right here by our actions at the county level. So I don't have any problem necessarily with saying that, we can move forward with that. And in the worst case scenario, I suppose, is that there is the only thing we're out from a county perspective is having to go back and redo an ordinance that may need amendment. So if we're discussing.
Is that a question that is wanting a response?
No, I don't think we need one.